Ladies and gentlemen, good morning and welcome to another ECLA online learning session. My name is Martin. I am the legal project manager of ECLA based in Brussels. And today I would like to welcome back Cian Farrell, who is the head of legal at Huawei Ireland. And then he will be talking about commercial contracts. And then more specifically, the title is Fast Food, Fast Love, Fast Love, Fast Law. Cian, the floor is yours.
Thank you, Martin. Hello, everybody. My name is Cian Farrell. I'm head of legal for Huawei Ireland. I decided to give this webinar on commercial contracts in the context of everybody being extremely busy. And this webinar is kind of directed towards those type of contracts that are not seen as a priority in terms of the value to the business, but as you're aware, there's always risk with contracts. So it's kind of those medium to small contracts in terms of importance, mid-level to low-level contracts. So the title was just going to be a catchy title around fast food, fast love, fast law. I think just before we get into the topic, I'll just give you a quick kind of high-level talk on Huawei. Huawei, as you may or may not be aware, is one of the leading global providers of ICT infrastructure and smart devices. A lot of people would associate Huawei with the mobile phones. We would have competitors such as Samsung and Apple. But Huawei is even bigger in the field of mobile network infrastructure, 5G, enterprise products. And you'll see from the slide there that we have a large amount of employees, upwards of nearly 200,000. R&D is particularly big, and particularly in Ireland, R&D is big. And that's obviously with any technology company, you want to have the best technology and the most advanced technology. And Huawei obviously is pushing that by investing huge amounts of money into the research and development of new technologies. In terms of Huawei Ireland, I think many of my Irish colleagues on this call may be surprised to know that Huawei Ireland is quite big. We would have roughly 500 direct and indirect jobs in Ireland. We're looking to create another 100 over the next few years. It says 65% recruited locally. That'll probably change now, given the market conditions. Operating in Ireland since 2004. We're headquartered in Dublin, and we've got 3 R&D research centres in Ireland. They're in Dublin, Cork, and Athlone. One of our biggest customers is obviously Air. We have Vodafone, BT, Imagine, and Cyro. We serve over 2.5 million people. Ireland has become a real focus for R&D development by Huawei, so the commitment is to spend 70 million over the next 3 years, and you'll see some examples of what we've done in the R&D field there. So let's get into the topic. As I said, it's about commercial contracts, and this is in a context where you have limited review time. And from my perspective, I've been a fully qualified lawyer for near 14 years now, going on 17. And I've found that in many instances, particularly when you're working in-house, that you are required to do timely reviews. And you may not be able to review the contract fully. And you also may not have the ability to change many clauses. So particularly where you're dealing with a contract, obviously that is not your template, because obviously your template is a lot easier. It's filled out and you send it out, and the other side comes back. This is where you're dealing with the other party's contract, and it's put in front of you. So it can be anything from a small kind of goods supply agreement, a services supply agreement, utility supply agreement, and you also probably won't have too much negotiation strength. So I thought that I'd keep this simple and really limit the scope of the review for the responsible, whether it be a legal counsel, contract manager, or whoever. So the four key areas that I thought to be concentrated on is term and termination, exclusion and limitation of liability, indemnities, and scope and pricing. So if we move on, the first one, which is very important, is term and termination. So you'll see all along the slides where I have negotiation strength, because as you're aware, unless you have some form of negotiation strength or some equilibrium in the relationship, it's going to be difficult to get some of your acts through. So the starting position when it comes to term and termination is that the supplier seller generally wants a minimum long lock-in period and less than straightforward termination rights. And the customer buyer usually wants flexibility. So with the supplier, what they tend to do is they will normally, you will see something where you're locked in for maybe a year. That would usually be something that a supplier would attempt to do, and then have automatic rollover rights, and then make the termination of that contract somewhat difficult, in that you are only able to terminate, for example, they say 3 months before the expiry of the relevant term. So, if your contract ends in December, you may have to give notification to terminate it by the end of September. So they have 3 months, prior notice. What happens there is obviously no one really pays attention, and then suddenly you slip into October, November, or November, and someone goes, "Oh, this contract's coming to an end," but in reality, they'll turn around and say, "Oh, no, because if you wanted to terminate for convenience, if you wanted to terminate, you had to give us 3 months prior notice," so it automatically lapses into another year. So that's a common ploy. So to get around that, I see that Rude has asked a question, and I believe I've answered it. Yes, the supplier loves to have a long-lasting relationship with the customer, and it's mostly the buyer would like to have the flexibility to terminate whenever they want, particularly if they feel that they want to analyze the market and they can go to another supplier or seller who can give better prices. Obviously, a lot of time it'll be non-exclusive, but the problem with it is that you will still could be legally bound to buy certain amounts a month or pay a certain service fee a month or whatever. So in terms of the supplier seller, as I said, they normally lock you in for as long as possible. And what clever supplier sellers do is they may say, "Oh, you're locked in for a year," but you have this automatic rollover. So in fact, it's almost like you're locked in for perpetuity unless you terminate. And then the termination rights are normally a little bit complex, as I've pointed out. For the buyer, so if you have a contract that has any of these terms, the simplest thing to do to give yourself flexibility is to try and get inserted into that contract a termination right for convenience and 30 days notice. And if you can get that, then you don't really have to worry too much about the term, because whether it's automatic rollover, whether it's long 5 years or whatever, if you can have a position where you can terminate on notice, 30 days notice, then I believe you're sorted from a term and termination provision. And normally you'll have something that simply says that you'll have to pay up. You have to be careful, obviously, that even if you get a termination for convenience right on 30 days notice, that you just pay for the period up until that termination date. And that's just something to keep an eye out on. So this is an example of a straightforward contractual clause. You'll see that I see that Karen's asking, does it impact the supplier's revenue recognition if you have a termination for convenience? In many instances, I believe it does, but I'm not an expert, financial expert. But yes, I think that is a big problem for suppliers, sellers. So you may have a battle on your hands there, but that's where the compromise is normally that there's a lock-in period for 6, 12 months. And thereafter it automatically rolls, but with a right to terminate for convenience at 30 days notice. So that's generally the way it will work. That's normally the compromise position. So in terms of the example I gave here, it says this contract shall commence on the effective date and shall continue for a period of 3 years unless terminated earlier in accordance with the terms of this contract. That's a very plain vanilla one. I think personally, I prefer the automatic rollovers as long as I can get a termination right for convenience on 30 days, because that means that we don't have to go back to the contract and extend it or amend it. Some people like to put in the 3-year period because then they feel that it would force the procurement to have a relook at it and take some action. I'm not sure that works. So I generally, from my perspective, is I don't mind automatic rollovers. I keep my eye out for lock-in periods, and I always try and get in a termination for convenience right on 30 days notice. But as I said, the compromise normally is that you have a lock-in that you can't terminate for the first 6 months or 9 months or 12 months, and thereafter you have a termination for convenience right. And then that kind of mixes up the revenue recognition. Also, a buyer supplier may say, well, I don't really want to deal with you if you can terminate in a month's time. So I need to make it worth my while and the pricing worth my while that I have a 6 or a 12-month lock-in. It could be longer. It depends on the product and or the services. So this the 1.2 here, it talks about unless terminated earlier in accordance with the contract may be extended upon mutual agreement of the parties for a further period of 12 months upon giving a written notice by the buyer to the seller that affect at least 3 calendar months prior to the expiration of the term. Again, this is a little bit of a hybrid where you have a fixed period and then you have to take some action in order to extend it. As I said, for small, medium-sized contracts, I like the automatic rollover. Yes, I see that Rude says automatic rollovers as a buyer force you to keep a very good tracking system to prevent automatic large payments, for example, for licenses you're not using anymore. It is an excellent point. I mean, this is where you need to marry your legal position as not having to revisit a contract all the time, but also hopefully have your procurement team or whoever ensuring that doesn't happen. And that's why in some companies, they only want to agree fixed periods for contracts so that the contract automatically expires and that there has to be some action, because in reality, they don't trust their procurement departments or whoever's looking after the contract. So that's something to take into account. As I said, from a legal perspective, I like the automatic rollover because I'm assuming that my fellow colleagues are reviewing contracts all the time, reviewing spend all the time, and seeing whether it's necessary. But it may not be the case. So again, as I said, the option is just to have a fixed period with the possibility to extend rather than an automatic rollover. Okay, exclusion and liability of. Okay, I see. So Sophia says, but unless you have a purchase obligation, the term of termination is not too important. You will be free to purchase from elsewhere anyhow. Yes, I mean that's where you have what you would have a framework, and that you only have a call off. But that's why I'm talking about contracts. This is really towards contracts where you have it's automatic purchasing, so that you churning out you pay on a monthly basis or a quarterly basis, and you keep doing that until the contract ends. In terms of frameworks, that's why a lot of companies may go down the framework perspective, but you've got to remember that a lot of the time these contracts are put in front of you. So if you're the buyer and you can dictate supplier terms, and you put your template in front of them, and typically that would be a framework that keeps on rolling, and that the only obligation to buy is when you issue a purchase order, and that's obviously one way to do it. So in terms of exclusion and limitations of liability, I think this is vitally important, particularly for suppliers, sellers, and buyers have to be beware of this, because obviously here where the supplier will try to exclude as much liability as possible and limit its liability at a very low level. So if I'm a supplier, I'll probably just keep it plain vanilla and exclude indirect losses, but you may look to exclude further. But normally I try to keep it plain vanilla from a supplier and exclude indirect losses. There's certain things you can't exclude, obviously, like fraud and everything. And then limitation of liability. A lot of suppliers, sellers will try and limit their liability at the amount of paid fees. So paid fees rather than fees. They want to make it very clear that it's the money that you've actually received. So that for me is too level a liability amount. So normally suppliers and sellers will look to limit their liability to fees paid over a certain period. So you would see that they said fees paid over the previous 12 months. For me, that's just not feasible in many cases, especially for the medium to small contracts, because as you're aware, it's quite costly to go to court. You want there to be some stick to beat the supplier or seller with. So I would normally look for a situation whereby I'd have a de minimis level, notwithstanding what's being paid to them. So we'll go on to an example here. So this is an example of a limitation of liability, which is what we've seen as favorable to the seller. So obviously you have, particularly in common law jurisdictions like the UK or Ireland, you would have where there's certain liability that you can't exclude. So death and personal injury, other examples include fraud. Then in terms of the exclusion of liability, normally a seller will look to exclude indirect losses. And then we look at clause B. This is where I've kind of put in an amendment here. The supplier wanted to limit its liability to the sums paid, and it says and or payable. So that's actually quite favorable, and there's no time period. But what we've done here is we've put in a de minimis level saying it's the greater of. So if what was paid and to be paid to the buyer for the relevant goods or services, the buyer, that would be the amount if it's over $500,000. But if it comes in at 200,000, then you can still go after them for up to $500,000. It just makes it the case where you're doing kind of small contracts. You don't want to get caught where you're only paying them 10, 15 grand or something, and then early in the contract, you know, that there's an issue and you've assumed, like, say, a couple of $100,000 loss. You want to be able to try and get in and recoup some of that. So that's a balancing. I'll just answer one of the questions here that has Rude says, so the common law, it's very regular to accept uncapped direct damages, e.g. breaches of privacy, confidentiality, third-party claims right fee. Yes, that is correct. And that's where you have to try and do, if you're a supplier or a seller, you will look just to cap your overall liability. But if you're a buyer or a customer, you will look for uncapped liability, particularly where there's breaches of privacy or IP. That is definitely something you would look for. The problem there is, again, is how much leverage do you have in the negotiation? So, for example, you could have a situation where you're doing a contract for Wi-Fi for the building of your company, and the procurement says we're not looking at anyone else, and these are the only guys to go with. So that kind of hampers you somewhat. So I would, Rude, if I were you and a buyer, would seek to carve out for those elements that choose. So there'd be uncapped liability. I wouldn't worry too much about confidentiality, to be honest. It's a very hard thing to prove, but privacy comes into it, particularly where there's a processing of personal data. IP, again, you look at it and you look at the type of IP and you see how valuable or potential valuable is, or unique it is. And then again, as I said, if you're a buyer, you would look to exclude those liabilities so they'd be uncapped, but it's very difficult. I see that Anna is going, do you need to fight for gross negligence or simple negligence is fine in many cases? There is some argument that gross negligence should be excluded. And then, for example, that it would just be plain negligence, so to speak. So that is something that people do argue over. But again, as I said, if I'm looking at a contract and I want to do it 100 miles an hour, I'm a seller, I will look to do my general exclusions, which are the ones I talked about, and then I will look to cap my liability at a low level. And if I'm a buyer, I may not be able to get many new uncapped liabilities into it, but I do want to ensure that the cap on liability is substantial enough to make them worry. Now it says here, do you expect you may cap these indirect damages to a higher cap than you would do for direct damage, for example, 2.5? In terms of indirect damages, generally they're excluded. But if you're talking about those, Rude, if you're talking about those areas that we discussed, IP infringement, data privacy, you can do a separate cap. Yes, that's very common. But again, it is an issue when you're dealing 100 miles an hour and that your procurement hasn't given you any other option and said, oh, we need to get these guys in, we need to get them in the next 2 weeks. So unfortunately, you may have to accept a contract, and that comes back to the importance of the termination for convenience right, so that you go, right, this isn't a great contract, but I know at least these guys can get out of it in 30 days. So that's what you do, just to give yourself a chance on that front. So I'll go on to the next one, which is indemnities. This is more of a common law thing than it is a civil law, because my understanding is that in civil law jurisdictions there isn't such a divergence between what a warranty and an indemnity is. Obviously, an indemnity in Ireland under common law is generally you don't have a duty to mitigate, so it's kind of a lot more straightforward claim, and you get a euro for euro amount up to the cap. So indemnities are very common in common law jurisdictions in relation to IP infringement, data privacy, and anything else that's deemed vitally important in the context of the contract. Suppliers, sellers will generally not want to give any indemnities, and they generally don't like to put an indemnity from the buyer, because then the buyer will seek to mutualize that indemnity. So that's an issue. So if I'm a seller or a buyer and there's indemnities in the contract, there is one way you can look just for a notification requirement within a certain, called preconditions, a notification requirement, and also ask put in a clause that means that they have a duty to mitigate, which effectively waters an indemnity down to a warranty. So they're the quick things I would do. Obviously, if you have more negotiation strength when it comes to indemnities, you will ask for a quick notification. You will ask for the ability to take over the case. You will have a duty to mitigate, and you will also have a clause that gets them to assist. Some people try and put in language around that your indemnity only covers stuff that can be shown to be you're directly responsible for. And that's something that you can do as well. But if I don't have much leverage in the negotiations, I tend to quickly look for just a notification right and a duty for them to mitigate, because some of the contracts are so small or medium that there's really no point in going on about taking the case over and everything and complicating the structure. Okay. So scope and pricing. So when it comes to contracts and I need to do them quickly and I don't have much time and I've been told that there's not much leverage in the negotiations, especially as a customer, I will go, right, I will look at the term and termination. I will look at limitation of liability, and I will look at indemnities. They're the three main things I will look at. Then when it comes to scope and pricing, I kind of say to procurement, this is something that you really need to look at. So normally the scope could be at the front of the contract if it's very kind of straightforward scope. Hopefully, if it like in many contracts, you have the scope and the pricing and the schedules, so that you simply turn around to your colleagues who are procurement colleagues, or your salesperson if you're on the seller supplier side, and you will say to them, guys, you have to run through schedules 1 and 2, and you need to double check them, because in reality, your lawyers, the commercial guys should do the commercial bit, but it can be problematic. So normally that's what I would do in parallel to quicken up a review. I will look at it, realize where the scope and pricing is, go back to the person and says, I'm going to review the contract. Can you review the scope and the pricing? Hopefully, to make it easier, it's in the schedules to the agreement, in which case you can do a parallel review. And as I said, I would then concentrate term and termination, limitation, exclusion and limitations of liability, and the indemnities to do it quickly, because what you get by doing the term and termination is what you're looking for, especially from a customer side. You're looking to get the ability to get out quickly. So obviously, you with the termination for convenience and 30 days notice, if you can get that in there, or compromise whereby you have a lock-in period for 6 to 12 months, but after that they can terminate for convenience, then I think you can be pretty comfortable if you can also get you ensure that the supplier or the seller, as I say, has a larger degree of liability commensurate with the amount of money that's been spent under the contract. And obviously, if you want to go to the next level, as appointed by Rude, would be you would try to exclude caps for IP infringement, data privacy, and confidentiality. I personally think confidentiality. I don't die in a ditch for confidentiality, but data privacy and IP infringement for me are very important. If you can't get uncapped for that, then obviously you can look to have a separate cap, but that can become problematic, and you may not have the negotiation strength. As I said, it's very important to engage with your procurement team if you're on the buyer side, to make sure that they know what they're looking at, and really would get them to review and ensure that they have something, and they're not agreeing too large minimum orders or anything like that, and that the pricing is straightforward. And particularly, I mean, you shouldn't have to be telling them this, but in many instances, you'll get clever supplier and sellers that they kind of have a bundled pricing, so you can't break down the pricing. You have to buy certain things all in one, etc. So, and that comes down to also, hopefully you haven't agreed to an exclusive buying one. So always go for non-exclusive, quick termination rights as well. I've now finished, so I'd like to answer some questions from anybody if they would like to ask any questions. I know we had a few through the webinar, but it would be very useful if people ask some questions so I can help. I see some people are furiously typing, so that's good. Okay. Sylvia says, on indemnities, do you think that another condition could be having control of the defense? Yes, that was one of the things I raised. If you're able to get that in, I said on a quick one and on medium to small contracts, I tend to just agree, a notification requirement, and as I say, a duty to mitigate. But if I'm a buyer and I think there could be significant issues in terms of an indemnity, then I would be looking for. If I'm the buyer, yes, I would be looking for control of the defence. Anybody would look for control, but it all depends on the value of the contract as well. So. But some people would just put in the ability to have the option to control the defence, which then you can make the call. I see that there's other people typing, so I'll just wait for that to come through.
It seems, yeah, that we have one or two more questions coming.
Yes, so Fiona, as a customer, is it usual to include liability for fines in the cap on privacy and to have recourse against the seller under Article 82 inside or outside a cap on liability? As a customer, sorry, I'll just read that again. As a customer, is it usual to include liability for fines in the cap on privacy and to have a recourse? So basically, the customer would look just to have an uncapped liability for anything to do with data protection. Normally that won't be accepted, and that you have to come up with a separate cap. The problem you're getting is you're getting to quite complex drafting there, so I don't know how much time you will have. So, I mean, people could say, you can keep the cap outside, so that again could come into exclusion. But as I said, the normal position is that the customer will look for uncapped liability for any data protection breaches, but then typically the middle ground is a separate cap, so a separate higher cap. So you may have a contract worth $1 million a year. You have the cap, the general cap is for whatever fees have been paid, possibly payable, or fees paid in the previous 12 months. Then you would have a separate cap, and you say $1 million. When you look at it, you may try and get away with like 5 million or 20 million, and you would agree a separate cap, and you'd normally throw in IP there. So that's on that one. And then the next question. Yes, Rude. The situation when it comes to indemnities is both parties generally will want to have control. And as I said, it all depends on the value of the contract. And that comes back to the liability position. The lower the liability for the buyer, seller, the less they'll have an issue with handing over control the lower the liability for the supplier, seller, the less issue they'll have with handing over any indemnity claim against the buyer, and vice versa. But as I said, you can either have, normally parties will put in an option to be able to control the defense. He says, if you're a seller, this is Jessica, if you're a seller, what kind of liability is standard to request for the buyer? So if you're what normally happens is sellers, suppliers have a contract that talks about their liability and is totally silent as the liability of the buyer. That's normally the case. And normally what you try to do is you would mutualize what the seller said on the grounds that, what's good for you is good for us. Also, a lot of people might argue that the buyer doesn't have too many obligations under the agreement other than to pay for the goods or services, and therefore, what kind of liability could you attract? I don't like that. I personally think you should set your liability commensurate with the liability of the seller or supplier. The problem you have, which some people try to do, is they try to include, which some seller suppliers accept, is where you basically says your liability is for whatever you owe under the contract and nothing else in terms of fees or charges. Some people try that. I think it's easier just to mutualize the clauses. They keep it quick. And as I said, I'm comfortable doing that on the basis that a lot of the liability rests on the supplier seller side. But again, that's the context of the contract. But if I'm really quick and I'm desperate to get a contract done, I'll just try and mutualize the liability and exclusion of liability clauses. Okay, I'll wait for one more minute just in case there's any more questions.
It seems that this is, I think
there's one more, I think.
From my side and definitely from the audience side as well, I would like to thank you sincerely, Cian, for yet another spectacular session. As we can see from the engagement from the audience, that this is a genuinely topical discussion that we're having. And then we at ECLA always welcome you back, Cian, and I hope that you know that
Okay, thanks very much, Martin. As I said to everybody, thank you very much for listening. From my perspective, as I said, if you're a buyer, short termination for convenient rights. If you're a seller, you want a lock-in period with robust committed spend. As I said, the compromise is normally a lock-in period for 6 to 12 months, and then a termination for convenience right after that. And then in terms of liability, there's certain things that are excluded. Liability is normally capped at fees paid or payable. Sometimes they put in a time period. My position is that you should put in a greater of and have at least a de minimis level of 500,000 or something like that to make it worthwhile. Indemnities, we've talked about that. Duty to mitigate, notification minimum, and then scope and pricing. Tell your colleagues to do their job and to help you out. Okay, everybody, thanks very much.
Thank you. And then from my side, we will be, this recording will be available on our website as well at dcla.eu. We won't have any other sessions this week, but we will have a discussion on digitalization next Tuesday on the 19th of May at 1100 Central European time. And then if you would like to listen to this recording or some of our previous sessions, then please go to ecla.eu and then listen to them there for free. And then from my side, then stay safe. And then thank you very much, Cian, once again.
Thank you. Everybody wash your hands. Thanks very much.
Bye.